24-20050. Ezell v. Dings. Is the appellant ready to proceed? You may.
Good afternoon, and may it please the court. I'm Ben Sachs-Michaels from Glancy, Prange, and Murray on behalf of the plaintiff's appellants. What I would like to do today is first discuss the district court's error in applying the motion to dismiss pleading standard. Second, why under the correct pleading standard the complaint states a claim for care mark violations. And third, why the misrepresentation claim should not have been dismissed. With respect to the pleading standard, it is settled Delaware law that factual allegations in a complaint are taken as true at the motion to dismiss stage. And these Delaware derivative actions frequently have, like this case, a very fulsome record at the pleading stage. They're based on books and records that are obtained prior to the lawsuit being filed. And so for that reason, the Delaware courts have developed a fairly substantial body of law about how courts are supposed to address the pleading stage inferences when there is a large pleading stage record behind the pleadings. So what the cases say is that where there are factual conflicts in the underlying documents that support competing interpretations, the plaintiffs have to be credited when they're well pled, which means that there's a basis for them in the documents. Where the documents support more than one inference, if plaintiff's inference is reasonable, the plaintiff receives the inference. And I think critically here, even if the court believes that an inference for defendants is more likely, it's required to credit plaintiff's inference at the pleading stage when it's supported by well-pled facts.
So you're talking about documents that would be ambiguous or documents that conflict amongst themselves, or what about documents that are entirely opposite what the allegations are?
Well, Your Honor, I think that if the documents completely undermine the allegations, then the plaintiff's allegations would not be well pled. So in this case, there's nearly 2,000 pages of board records, and plaintiff's facts exist in the record. They are supported by the documents, but perhaps predictably with 2,000 pages, defendants have identified facts that support their argument as well. What the cases say is that in that situation, the court is required to take plaintiff's facts and give plaintiffs the inference where it's reasonable. So here, where both sides are seeking competing inferences based on facts that are in the record but conflict with each other, the plaintiff's facts are taken as true. What we've alleged is that there were a stream of red flags presented to this board. There's a 2010 consent order. There's unremediated gas migration allegations that go on for 8 years in some cases. Then there are new defectively drilled wells that produce new gas migration allegations after the 2010 consent. There are escalating warnings from the regulator that the company is not complying with the law and the consent. There's a grand jury finding that the company took no action until recently and for nearly 8 years refused to acknowledge and correct the violations of Pennsylvania law.
Counsel, can we back up just a minute? I understood from the briefing that you took issue with the way the district court used or acknowledged the other documents, in other words, materials that are judicially noticeable at the 12B6 stage, but it sounds like today you agree that the district court did not err in using the documents, you just disagree and object to how they were used to fashion the court's ruling. Is that correct?
That's exactly correct. Yes. What we assert is that the red flags that I just identified, which are objectively in the record, show that the board knew that there was a sustained failure to comply with the law over many years. And what the documents also show is that the board passively observed. It was informed about the problems, but it took no meaningful action to address them. So those facts are well pled. That is in the record. They must be taken as true here. And the district court, in dismissing the case, understood our allegations and, in fact, summarized them accurately, I think. But then what the district court did is the district court discussed and focused on defendants' conflicting interpretation of the facts from the same documents. And I think the critical passage to me is near the end of the opinion, the district court acknowledged that, quote, the 220 documents show some successes, some failures, but, quote, show that Cabot was working in good faith to remediate defective wells and restore contaminated water. And I think that exemplifies the point I'm trying to make, which is that inference that it shows Cabot working in good faith when the court has already acknowledged that the 220 record, the court isn't saying that plaintiffs misrepresented the 220 record. The court is simply choosing defendants' interpretation and giving defendants the inference. And the cases that we cite, that is just not the correct application of the pleading standard in this situation. And so turning to the Caremark claim, if we apply that pleading standard to the Caremark claim, under Caremark, where there's a failure of the board to take meaningful action in the face of sustained red flags, alerting it to illegality, that supports an inference of bad faith. And there have been a number of cases developing this in the last several years. The Boeing case, the court described this test as asking whether the board was aware or should have been aware that its response fell short. And the Walton case.
So where do we make a distinction between the board being aware of certain things, which I think you've outlined pretty well in your briefing and in your complaint, and the board taking action or agreeing, having representations that actions have been taken, versus bad faith, where the board is either out to lunch and inattentive, or worse yet, seems to encourage inactivity. In this case, it seems like the board does receive regular updates about gas migration issues, and they are receiving information about efforts to resolve them. So how can we discern what the tipping point is between inactivity and acceptance of explanations and bad faith where we're condoning the things that you're complaining about?
We would start by directing the court to the Walton case. And the Walton case involves Walmart, so it's different facts to some extent, but the fact pattern is analogous. That case starts with a consent agreement. So there's a violation of the law, and then the company agrees to resolve it by taking on heightened responsibilities. And in the Walton case, as here, over a period of many years, the board was receiving information that the company's remediation efforts, and there were some, were not working. And that's what we have here. The board is being told 8 years for some of these wells. The board is being told, we're remediating it. At some point, clearly, the remediation wasn't working. And I think more importantly for the investors, what matters is mollifying the regulator so that the company doesn't get criminally convicted. And the board knew that the regulator didn't think that the company had remediated the issues. And it's not just like 6 months that we're talking about. We're talking about many years. And so in Walton, what the court said is that although the board had implemented some policies and directed the management to repurpose a software system, that it didn't take meaningful action to improve the company's ineffective remediation efforts, even as it received escalating warnings from the regulator. And so here, I think the error below, and this sort of, I think, addresses the question to some extent, is that there is a difference between the company's remediation efforts, which the board was overseeing, and then the board taking action of some kind when it knows that the company's efforts are inadequate. And we have management doing ineffective remediation here, but we have the board being told the remediation is not working. And that's the situation where the board has an obligation to act or to take meaningful action. And so here, what I believe a fair reading of the record is that the board just passively, it received all this information. There's nowhere in the record that we're aware of, and I didn't see anything in Appellee's brief either, where the board took some kind of meaningful action. Let's implement a new system. Let's change our standards.
Wasn't the board also receiving some information from consultants reporting that things were getting better and that some of the problems were being ameliorated?
It was. It was receiving, over a period of years, again, the company had a consultant called Stantec. And this consultant was producing closing reports, which were supposed to be showing that the problems were remediated, but they were on multiple occasions over the course of these years rejected by the regulator. So this is, again, to take it back to the Walton case, in Walton, the allegation was that when the company became aware that the penalties for violation of the consent order were going to accrue, all the board did is consult with attorneys, and that wasn't enough, and the motion to dismiss was denied. Here, the board didn't even do that. The board just stuck with the same ineffective consultants, and I think the cases that we've cited in our brief set out pretty clearly that at some point the board has to take matters into it, has to do something when it knows that the remediation isn't working, and simply hiring a consultant that isn't fixing the issue doesn't insulate it from liability. Or I think, to bring it back to the pleading standard, doesn't undermine the inference of bad faith that we're seeking on the basis of the well-pled facts. So here, the board knew that the remediation efforts were not effective, that there were new problems occurring. So that means that not only are they not complying with the 2010 consent, but the company's drilling practices going forward are also producing these problems, which means that they're also not being done properly. Then the regulator over and over and over again accuses the company of breaking the law and not complying with the 2010 consent. I think the district court—
You agree that there was an appearance, at least, that efforts were being made to remediate?
Yes, Your Honor, I do. I think that the distinction that we're making is that efforts to remediate that are over a long period of time ineffective are not sufficient.
So you're not alleging it was a sham?
No. What we're alleging is that the board knew that the remediation efforts weren't working and still just sat by passively.
Should I be concerned at all about this Rule 23 pre-suit demand?
Well, I think, Your Honor, this all ties into that, because the way that we excuse demand here is we have to show that there's a substantial likelihood of liability as to half or more of the board, so it's 5 directors. And the way that we get there is alleging that there was this Caremark violation, because under Delaware law, if you've alleged a Caremark violation, which necessarily supports an inference of bad faith, that's non-exculpable conduct, and that would require denial of a motion to dismiss, both as to the underlying claim under 12b-6 and at the 23.1 stage. So the two inquiries collapse to some extent.
But don't you have to plead that against each of the directors individually? It's not a broad brush. It's something that you have to identify with each of the individuals, correct?
Correct, Your Honor. And the complaint fulsomely pleads chapter and verse of the dozens and dozens of meetings that each individual director attended and what they knew. And so we respectfully submit that we have checked that box in the complaint. What I think the district court misapprehended, it was asking whether the board was informed. And when it concluded that the board was informed, it said, well, that's good faith, that's good enough. And that's not enough under the cases that we've cited. And I think to dig a little deeper on that, really probably where there's a misconception is the district court looked at the Walton case and distinguished it on the basis that the board in the Walton case, said the district court here, took no action to implement a monitoring system, and that's record site 1589 and 1590. That's simply not what the Walton case says. The Walton case says that the board took action, it just wasn't meaningful enough to avert the corporate trauma. So another element that I think the district court didn't address in its opinion, and that is also crucial under Delaware law, is that this is a criminal violation. This isn't like a fine for some sort of civil violation. This company was criminally convicted. And under Delaware law, the Facebook case that we submitted in our addendum addresses this in depth, but under Delaware law, criminal conduct it's impermissible for criminal conduct to be the cost of doing business. So a board may not defend against claims of breach of fiduciary duty on the basis that they had made a cost-benefit analysis and a slap on the wrist in the form of some sort of inexpensive criminal sanction was worth pursuing an illegal course of conduct. So when you take together the fact that the board didn't take meaningful action, and then what it resulted in was actually a criminal sanction to the company, that supports the inference of bad faith, I think beyond the applicable pleading standard. So when we take our facts as true here, and we apply the inference that is reasonable based on the facts, what we get is we stated a Caremark claim, and the motion to dismiss should have been denied. With respect to, if I may quickly, before my time runs out, to the disclosure allegations, It's really another version of the same issue, which is that the district court didn't take the facts in the record as true. We're talking about 2 disclosures in 2019 that the company made about several wells where they had received gas migration complaints, and the regulator had issued notices of violation. And the company claimed that it had performed appropriate remediation as to the wells, the several wells, without identifying them. And with respect to the wells at issue in a June 2017 notice of violation, that it believed the water quality complaints had been resolved. That's a quote. And resolved is the key issue here. What the record shows is that the water quality complaints were not resolved when these statements were issued. The board minutes described the gas migration cases as open, but I think more importantly, defendants submitted the ultimate regulator order as to each of these wells, and they both show that as of the issuance of these statements in October 2019, the cases were not resolved. The Howell well, it was not until September of 2020, at conclusion of testing, that the remediation was shown to be complete. And with the Jeffers well, there were complaints ongoing as of February 2020. Very quickly, the demand board was on the EHS committee. These directors not only were aware of the company's lack of compliance, but they also, subject to the EHS committee charter, had an obligation to oversee external disclosures about environmental data and outcomes. They were required to do that under the company's governing documents. So the reasonable inference here, based on what they knew on the record, and based on the fact that this was an environmental disclosure, is that these directors were aware of it. The pleading standard requires the facts to be taken as true. What defendants do is they, again, predictably, as I would in their position, identify other facts that they say undermine our argument, but there's not some kind of direct evidence that these wells were remediated before the statements were made. And the district court, we think, decided correctly when it denied the motion to dismiss as to those statements in the securities class action. Same result should occur here.
All right, thank you.
Thank you.
Mr. Stokes,
Yes, Your Honor.
you may proceed.
Thank you, Your Honor. If it may please the court, I am Peter Stokes of Norton Rose Fulbright, and I'm here presenting argument on behalf of the appellees, the defendant and nominal defendant below. I believe that both parties, both sides in this case, agree that the standard the plaintiffs must satisfy to excuse demand and to plead a claim is bad faith. The plaintiffs have to plead a non-exculpated claim showing bad faith, which requires knowledge that a majority or at least half the directors knew they were breaching their fiduciary duties or knew they were making misstatements. And regardless of whether we are discussing the disclosure claims or the oversight claims, the plaintiffs have to plead knowledge, and Judge Rosenthal was absolutely correct that they failed to plead such knowledge. They failed to plead an underlying breach of fiduciary duty, and her treatment of the record documents, I believe, was entirely consistent with how Delaware courts have treated these kinds of records for years and years in oversight cases. With respect to the disclosure claim, if it's all right with the court, I'll address that first because the plaintiffs' counsel addressed that last. The disclosure on its face specifically says that the notice of violations at issue have not yet been resolved. It specifically says that if they're finalized, we anticipate a consent order or an order will be entered resolving the violations. But they make clear, crystal clear, as Judge Rosenthal found, that the underlying violations were still open. They had not been finally resolved. And in fact, with respect to the November 2017 notice of violation, the company still had to submit a detailed remediation plan. So no reasonable investor reading that disclosure could be misled into believing that all remediation had been done and the regulator had declared that the files were closed. So that the plain language of the disclosures expressly refute that claim. And the securities class action involved some additional claims involving production guidance that are not part of this case. I don't believe the plaintiffs have ever argued that the ruling in the class case on the motion to dismiss has res judicata or estoppel effect. And Judge Rosenthal got it right in this case, which is the ultimate issue. She looked at the disclosures, zeroed in on the language in the 2019 disclosures, and correctly concluded that those disclosures were not misleading, and in fact, they were 100% accurate. She also concluded that the board records and allegations with respect to those disclosures substantiate on the oversight claim that there was no bad faith intentional failure to remediate by the directors. I do take issue with the characterization of the record that the board had been repeatedly told that remediation was unsuccessful. They were told that the Pennsylvania regulator, the Department of Environmental Protection, had disagreed with respect to some of the wells, not all, but some of the wells subject to the DMIC consent order had been completely, that all obligations under that consent order had been completely fulfilled. And there was dialogue back and forth over a period of time with the regulator where testing was done. It was not simply meeting with a law firm, as in the case cited by appellant's counsel, but it was, they had consultants' reports, there were discussions with the department, there was testing, many tests were done, and management and the board looked at it and concluded that the company was taking action to remediate. The regulator had not approved everything yet with respect to the consent order. So the company went to the regulator and said, tell us exactly what we need to do. And finally, in June of 2018, the regulator sends this letter that's cited in the complaint. That letter again says there's been remediation or complete compliance with some, but not all of the wells subject to the DMIC consent order. And here's what needs to be done. And from that point forward, there's no allegation that that letter was ignored. In fact, not even the Commonwealth of Pennsylvania, the Attorney General alleges that no remediation was done. In fact, the remediator, I'm sorry, even the grand jury report concluded that as of mid-2018, i.e. after June of 2018, there was remediation that was done. So the company did take action with respect to the remaining wells, and there's not a bad faith failure to remediate. And on the Walton case that the opposing counsel cites, and as with a number of these other cases that are cited, there were inferences in those cases that there was a substantial amount of revenue being earned by the company through unlawful activity, such as selling of opioids for improper purposes. And there's no inference like that in this case. To the contrary, the company wanted to get access to the DMIC box where the geographic restrictions had been imposed. And again, they were trying to get access to the box. They were going to the regulator, trying to find out what else needed to be done. There were discussions. It wasn't 100% smooth sailing, but ultimately they got that letter and they proceeded with getting access to the box and reaching an agreement with the government. And
so let me ask you: isn't the period of time a function of consideration of bad faith? In this case, I believe we started in 2009 or 2010, and this is ongoing. I mean, at what point is there a critical mass where we can infer bad faith, at least from the pleadings, and which is what the stage we're at right now?
That's a good question, Your Honor, and I think that the MoneyGram case really speaks to that. That involved over 5 years of alleged noncompliance, and the court looked at the nature of the allegations in that case as being more important than the time period. So here, there's no camera down the wells that shows whether gas is migrating into groundwater. By the admissions of the plaintiffs, and especially the citation to the Ely case, ELY, in paragraph 146, it was a complicated, disputed process involving circumstantial measures of gas readings in groundwater. There was already pre-drill methane in the groundwater, so it wasn't like, and the Ely verdict in that civil case was overturned by the judge for insufficient evidence because there was pre-drill methane that predated Cabot's arrival in the area. So it's more a function of the nature of the allegations here. And these are allegations, these types of gas migration issues, there's not a black-white switch where you know immediately that you have remediated the issue. There is a long tail period of testing, months, years of testing that the department wants to see to make sure that methane has cleared out.
Denied that there were numerous violations over a number of years.
There were a number of violations over a number of years, but as a percentage of
Some of the violations were repeated violations. In other words, this is what you're doing, this is what the problem is, this is what you need to fix, and then the next year, we still have that problem.
I don't quite agree with that characterization, Your Honor. I think there were violations that were cited earlier where they had an obligation under the consent agreement to bring wells into compliance, and there were steps that were taken. But importantly, the department never moved to enforce or find the company in contempt or violation of the consent order. They had the power at all times to restrict or shut down the company's operations, to bring a claim for enforcement of the consent order, and they didn't do that. They worked with the company over a period of time to try to bring these issues to a close. And again, there's nothing in the record. In fact, on page 17 and 18 of our brief, we cite how in the 2017 board minutes, the board is being advised the company believes that we have complied in full with the COSA. And there were disagreements about some of these wells, but these were only a small number of the overall over 700 well sites the company had during that time period. So it's interesting on that point that the plaintiffs originally had a disclosure claim alleging that the disclosures about substantial compliance were untruthful, and Judge Rosenthal dismissed that claim, and they haven't advanced that on appeal. So on the one hand, they haven't disputed on appeal for disclosure purposes that the company could properly say it was in substantial compliance. But on the other hand, they're trying to assert that the oversight of that compliance was so egregiously bad that it rises to the level of intentional bad faith. I submit those are inconsistent, and I think that again goes back to the timing point here, that it's not simply a function of time, because it does take a long time to determine whether the testing has sufficiently demonstrated what the regulator wants it to show. But with respect to the remediation that was done, there's no instance where the plaintiffs can cite in the record that the company was told you have to undertake this particular fix, and the company said we refuse to do that, or that the company's own readings showed that there is absolutely evidence that we subjectively in bad faith believe that wells have not been remediated. There was a disagreement with the regulator, and they worked with the regulator over time to come to a resolution. And in the Jacobs case involving Qualcomm that we cite in our brief, the court made clear that companies don't have a duty, boards don't have a fiduciary duty to simply acquiesce to a regulator's point of view. It is a permissible decision by a board to contest a regulator.
Counsel, what are we to make of the grand jury finding that says Cabot has only recently taken steps to remediate some of the gas wells that had been in place for a decade? It's probably not much daylight between willful ignorance and bad faith. Why can we not make an inference based upon that statement?
Because that is, Your Honor, that's a backwards-looking allegation by an outside regulator. It doesn't reflect what the board was being told in real time. And these have to be particularized allegations of fact showing what the board knew. And this is an after-the-fact view by a regulator that doesn't name any individual directors. It doesn't speak to individual directors' knowledge. It's simply a characterization that the company in real time never agreed with. There was never any hint in the board records during 2018, for example, that the company, that the regulator believed the company was currently in criminal noncompliance with the law. There was no hint that the company, until very shortly before they received that grand jury report in June of 2015, that felony charges would be on the table, and the company was never convicted of a felony.
I guess that's why I'm asking. I use the term, willful ignorance, which I realize isn't the standard here, but nonetheless, at some point there's a duty to inquire if it arises, as Judge Graves illustrated, if it arises repeatedly, at some point a director would have some duty to ask or to inquire further, or rather than just accept a statement from someone who's on the inside of the enterprise, right?
I think the record here reflects that the board did inquire, and they had a committee every quarter that did receive a detailed report showing all the activity that was being commenced and conducted with respect to each of these wells. And with respect, again, to a large number of them, there was no further violation. And even the June 2018 letter recognized that there was compliance. It wasn't, in the regulator's eyes, compliance with everything, but the regulator took the position that some of these wells hadn't been remediated. That is not, we believe, a conclusion that one could support from looking at the underlying test results and data that the company was looking at. What they knew was that the regulator was not fully satisfied as of 2018 that all the wells had been remediated. But they did not have any basis they had a more than good faith basis based on the reports that they received by the company's efforts, the consultants, the testing, the repeated dialogue with the regulator, that management did have a good faith plan in place to address the various wells. And the record also shows that with respect to the timing, there were often significant gaps between the time the company would submit a response to the regulator and the time the regulator would actually respond. So, for example, that June 2018 letter references a closure report for the Ratzel wells that was submitted in 2015, almost 3 years earlier. And the record demonstrates that there were, and we discussed it in our brief, that there were multiple incidents where the company had made responses to the regulator, and there was a significant passage of time before they received a response to the company's response. So there was a significant, it was not, again, a flip the switch kind of issue where the company could simply remediate everything in 2011 or 2015 and never have to file another report again. It was the nature, as in the MoneyGram case, the nature of the allegations here, the nature of the issues are issues that are inherently disputable. They're issues that are inherently circumstantial. There's no way, looking at, again, the way a well operates, there's no way to know with direct evidence whether methane is improperly migrating from a well. It's all through circumstantial evidence of methane readings in groundwater, and there are many reasons why that groundwater methane could be elevated. There's also, in the statute itself, we cite on page 51 of our brief, the statute in the Pennsylvania regulation 25 PA Code 78A 85A5, which deals with what gas flow cannot be found in the annular space. And that regulation only prohibits gas flow in certain annular spaces, not simply the presence of gas itself. And whether there's actually flow as opposed to merely a presence of gas, again, that's something that illustrates that this is not a simple flip the switch kind of operation where it would be self-evident to a board that there is obvious noncompliance. And the Delaware cases over and over again talk about how even cases where they characterize the oversight as being bad oversight, or negligent or grossly negligent or even recklessly indifferent oversight, In MoneyGram and other cases, the courts have consistently said even bad oversight is not bad faith oversight. There has to be an inference of not simply reckless indifference, but actual knowledge that the company is engaging in illegal activity and the board isn't simply taking too long to fix the alleged issues, but is simply not interested at all, that it's deliberately looking the other way because that they want the company to rake in profits from unlawful activity. And that didn't happen here. There's no allegation, again, that the alleged noncompliance issues here were material to the company's bottom line. There's no allegation, again, that the substantial compliance disclosure claim was rejected by Judge Rosenthal, and I think the fact that they haven't tried to resuscitate that on appeal is highly telling on the bad faith issue, because if there is substantial compliance, if they're not disputing that on appeal that there was substantial compliance for disclosure purposes, I think it's awfully difficult to turn around and say there's bad faith oversight of the compliance function. With the NOVs, these NOVs, they don't plead, notice the violation, they don't plead facts as to the vast majority of them, as to what they were. The vast majority didn't carry any penalties at all. And the number of violations found was only about 1% to 2% of the inspections that were done. So they would inspect, for example, they did 1,731 inspections in 2018. They only found 104, there were 104 NOVs with total penalties of less than $11,000, as reflected in paragraphs 180 and 227 of their complaint. Again, in looking at bad faith compliance and whether this tips over the line, these kinds of numbers simply come nowhere close. And there are legions of Delaware cases that talk about far more catastrophic examples of noncompliance, including even in MoneyGram, where there was a $125 million additional penalty imposed at the end by the government. The penalties here don't come close to that. The alleged harms here haven't approximated that. And the bottom line, again, the board record was appropriately considered by the court, and Judge Rosenthal emphatically and correctly found that there is no inference of bad faith in this case, certainly not substantial likelihood of liability, and I thank the court for your time.
Thank you, counsel. Rebuttal.
Thank you. So I think that Appellee's arguments here illustrate the point I was making earlier about the pleading standard, which is that these are fact-based arguments. The arguments about the amount of time it takes to communicate with the regulator and the back and forth and the scale of the harm, these are all fact defenses that are appropriate at a later stage of the case. The question here is only whether there are facts in the record to support plaintiff's allegations, and there are. Caremark applies in particular to highly regulated industries like this one, and that's because the oversight of the regulator is an important part of the company's ability to do business and the board's fiduciary responsibilities to the shareholders. What occurred here was not a mere disagreement with the regulator. The company was criminally convicted. I think that the Facebook case, again, goes into this in quite a bit of depth, and the issue isn't only a one-off violation of some kind. It's that there is a predicate, which is the 2010 consent order, which isn't just to comply with the law. The company agreed affirmatively to additional heightened compliance that it never achieved. The question of whether knowledge has been directly pled is also something that the cases address. And the Walton case has a good insight on this, which is that directors at publicly traded companies are sophisticated, well-advised individuals. Rarely is there direct evidence of knowledge of wrongdoing in board minutes that are produced in this sort of pre-suit process that we've engaged in here. The way that we get to that is through the inference that we discussed earlier. We aren't required to have direct evidence that they acted in bad faith. There does not need to be a document that says they knew that the company was violating the law. We infer it at the pleading stage, and then it will be subject to proof. The issue here is whether the board took meaningful action. It seems that we may agree on that. I think the Richardson case, the MoneyGram case, compared to the Walton case, illustrates very clearly what the distinction is. In MoneyGram, the board took action in response. It established a new committee, it purchased new risk software, and it negotiated an extension to the deferred prosecution agreement. Here, there is nothing in the record, and I haven't heard any identified by appellees, that shows that the board took any kind of meaningful action or made any kind of meaningful business decision to avoid the corporate trauma or to address the company's ineffective remediation efforts. The last point I'd like to make is just about harm. There is not a rule that a certain percentage of NOVs, of notice of violation as a percentage of wells, rises to the level of liability. There isn't a rule about the size of the penalty. This is, again, a criminal conviction, which is an unusual and severe sanction for a publicly traded company. And I think that the record here is replete with the harm that befell the people, the farmers on the land where they drilled these wells. People were lighting their tap water on fire. There is a person who they drilled the... I apologize. I'm out of time. Thank you.
Thank you, counsel. The court will take this matter under advisement.